Well, welcome on this Friday the 13th, September 13, rainy day. I am so excited to see all of you here this morning as part of our annual kickoff to Constitution Week and celebration of Constitution Day. At this time, I would like for you all to please stand for the presentation of colors by the Santa Lucis High School Criminal Justice Honor Guard, and remain standing for the Pledge of Allegiance.
Honor Guard, right shoulder, arms. Forward, march, left, 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 left. Mark time, march, left, 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 left. Detail, halt. Left, face.
I pledge
Present, arms.
I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Order, arms. Right, face. Forward, march. Left, 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 left. Detail. Halt. Halt.
You may be seated. Again, I would like to welcome all of you this morning to our 9th annual James Otis Lecture Series in honor of Constitution Day. I am so thrilled to see you guys and also to be partnering again with the Palm Beach chapter of ABOTA. We have a fantastic program lined up for you this morning. We're going to test your knowledge, and we're going to have a little bit of fun with you as well. So without further ado, we have some special greetings this morning from two very special people who have joined us. First off, we have our Chief Academic Officer, Dr. Glenda Sheffield, followed by our School Board Chair, Mr. Frank Barbieri.
Good morning. Good morning. Thank you to, as we get started this morning, I do want to make certain that we thank the Palm Beach chapter of the American Board of Trial Advocates and the F. Cunningham Bar Association. Also, we'd like to say thank you to all of the judges and attorneys who are participating as guest speakers. I think that we have with us this morning Judge Simone Rowe with the Circuit Court 15th Judicial Circuit, Judge Samantha Fuhrer, Circuit Judge 15th Judicial Circuit, and Judge Connor, Appellate Judge 4th District Court of Appeal. So thank you to all of our judges that are with us this morning. Also, we would like to say thank you to the members of our Choice Department that have done an outstanding job putting together this outstanding event. So Dr. Johnson and your staff, I do want you to know how much we appreciate what you all do on a daily basis for advocating for our student learners. And thank you to our dear, dear students. It's all about you, and to the teachers and the chaperones on what you're doing on a daily basis and making sure that we are providing a safe, nurturing, and a worldwide experience for our student learners. So thank you. And at this time, I think it's very appropriate that we ask that our teachers, the chaperones that have made this way possible for getting our students here this morning, to please stand and be recognized. And I mean it from the bottom of my heart, because I know we do not say thank you enough for the job that you do and stepping outside the box, and many times, as we all say, neglecting yourself and your families for making certain that our student learners are indeed taken care of. And joining us, some of the schools that are here with us, is our criminal justice academies from Jupiter High School, Glade Central, Lake Worth High, Forest Hill, Santa Lucius, and then we also have our pre-law academies with LC Swain Middle, Yeager Middle, Logos Run, Palm Beach Lakes, and Spanish River High School. So all of my students, I know that you're sitting, but I'm going to tell you to exercise, get up so that you can be recognized as well. So all of my student learners, you're going to stand. Thank you so much. Students, you may be seated. And students, today, it's about you today as we are celebrating Constitution Day for 2019. And I just want you to know, students, that we do indeed want you to enjoy this experience. We appreciate you as student learners and the efforts that you're putting forth every single day. So again, thank you. Thanks to everyone that have taken time out of your busy schedule and being committed and dedicated to what we are doing with our student learners, because it indeed takes an entire village, and we appreciate the time that you're spending away from your offices, because we know when you get back, the work is just piling up waiting on you. So we definitely appreciate it. I do want to apologize to all of you that I will definitely have to be stepping out. Doran has changed some things for us within this district. It definitely bypassed us, but we were out a few days. So today we are doing some budget adjustments, which I definitely need to be a part of, making certain that I'm advocating for the assistance and so forth, in which we need to make certain that are going back into our school centers. So I am asking that you please forgive me for having to leave you a bit early this morning, but I want you to enjoy the day. And as we talk about the adjustment in schedules, we've had so much that have occurred within the first 4 weeks of school. And most importantly, I think it's very appropriate for us to just stop and have a moment of silence for our families that are over there in the Bahamian Island in terms of what they've just experienced, and as we are welcoming those families into our schools and making certain that the students are taken care of. You know, my heart continues to ache, and I just want us to stop and just have a moment of silence for our Bahamian families. Thank you, and again, I will turn it over to our board chair, Mr. Barbieri.
Thank you very much, Dr. Sheffield. Good morning, everyone. I was quick to accept the invitation to come and welcome you today, because I welcome any opportunity I can get to speak to our students, especially those from the criminal justice and pre-law academies. You probably don't know that aside from being the chairman of the Palm Beach County School Board, I am a practicing attorney for a firm in Boca Raton, and before that I spent 11 years as a police officer. So for me, today represents my two professional passions and what they have in common, the law of this great nation. In order to go into either of those fields, you have to have a firm understanding and appreciation for the United States Constitution and the rights that are afforded us as citizens of this country. However, even if you complete your studies in these academies and decide on not pursuing a career in law, or you decide that criminal justice is not in your future, it is still so important that as young adults you take the time to understand the importance of the Constitution and what it means for all of us. If you watch the news or follow Twitter, you see claims daily that the Constitution is under attack. And while you're young now, it may not seem like that matters, but it's important to expose yourself to the laws of this country so you can make informed decisions about the government that represents you, the people that you vote for, and even what the media is telling you. It's vital to have an understanding and to be informed citizens in our community, because before you know it, we'll be counting on you to make the right decisions for all of us so that this country can continue to thrive and be a model for other countries in the world. I want to thank the Department of Choice and Career Options and Dr. Johnson for the work that it takes to put this event together each year, and thank our fine speakers for sharing these experiences with our students. Students, you are being given a tremendous opportunity this morning as these judges and attorneys have taken time from their busy schedules to share their expertise with you. Your attention today, and more importantly, what you do with the information you learn, is the greatest compliment you can give these speakers, your teachers, your parents, and yourself. Enjoy what this experience is offering you, and I hope all of you have a great day. Unlike Dr. Sheffield, as chairman of the school board, I've got meetings most of the day today, so I won't be staying with you, but I hope you all get a lot out of the program that's been prepared for you. So thank you very much.
Good morning, everyone. My name is Rebecca Brock. I am a trial lawyer with the Law Office of Kibiki Draper here in West Palm Beach, and I'm also the president-elect of the Palm Beach County chapter of ABOTA. So ABOTA stands for American Board of Trial Advocates. We are a national association. We've been around for just over 60 years. We're made up of over 7,600 members. We are made up of lawyers, equally balanced between those who represent plaintiffs and those who represent defendants, as well as judges across the United States. And we are all invited to be members of ABOTA based on our trial experience. In ABOTA, we have several purposes and several missions. One of those, and one of the primary mission, is to promote the preservation of the right to a trial by jury. That was established in the 7th Amendment of our Constitution. And how we go about promoting the preservation of the right to a trial by jury is by getting out and educating you all and people in the community about the value and the importance of the right, of this precious, precious right to a trial by jury. A right that William Rehnquist, the former Chief Justice of the United States Supreme Court, said should be jealously guarded. In ABOTA, we also promote the independence of the judiciary, and we also, of course, promote civility within the practice of law. So on behalf of the Palm Beach County chapter of ABOTA, we are thrilled to be here with you all today to participate in this James Otis Lecture Series and celebrate Constitution Day with you all. Anybody out there by any chance know who James Otis Jr. was? All right, well, that's what I kind of thought, because that was me as well. I didn't know who he was. And in reading about him and learning about him, arguably he was one of the most influential lawyers in early American history. Because remember, back in the 1750s, when the British controlled the colonies, there were these things called acts, ACTS of trade, acts of trade. And the British government had instituted these acts of trade, which were a series of laws that were designed to really restrict trade between the English and the colonies, and really, quite frankly, the rest of the world. Well, as you can imagine, the colonists in New England and the merchants, they didn't like those acts of trade because it didn't let them make money. So they started doing something they shouldn't have done. They started smuggling goods to try to make more money. Well, as a consequence, the English government imposed what were called writs of assistance. And writs of assistance were generally search warrants. These search warrants would allow customs officials to go into people's businesses and homes randomly, without announcement, for no reason, and search for contraband. Well, back then there was no system of checks and balances, so you can imagine how this got out of control. And James Otis Jr. said, I'm not having it anymore. So he decided to represent Boston merchants in the fight against writs of assistance. So in 1761, he stood up and he gave this eloquent, inspiring 5-hour speech. And in that speech, you may have heard the phrase, a man's castle is his house. That's where that phrase came from. Well, this speech, which went on for 5 hours, made James Otis Jr. a rock star in the colonies. They loved him. The crowd went wild. He was so well received, he became quite a local celebrity, which we'll get back to in a minute. But in addition to making him a celebrity, it did something else. It inspired people in the audience, like John Adams and some other people, so much that it actually has been said it lit the spark that ultimately led to the American Revolution. So on September 17th, 1787, 39 men gathered in the Independence Hall in Philadelphia and signed the U.S. Constitution, the foundation of our democracy today. So I told you we'd get back to James Otis Jr. Well, the fame actually figuratively and literally went to his head, because apparently in his rise to fame and his enjoyment of his fame, he became very agitating. So much so that one particular man hit him over the head with a cane. And it apparently led to the rest of his life suffering from some sort of mental instability until his death in 1783 when he was struck by lightning. Shocking, huh? Yeah, so not the best denouement for James Otis Jr., and he doesn't go down in the history books hip like Hamilton, but we should all be grateful for James Otis Jr. for the good run he had while he had it, because we continue to benefit from his passion, and one of those benefits is the right to a trial by jury. So we hope you enjoy our presentation today. We thank you for being here. We encourage you to be interactive and ask questions. You have 3 incredible judges with you today. You're really lucky. So thank you so much for being here.
Good morning, children. I can tell we've got, looking around, a fine group of young people from our schools in the county. My name's John Lurvy. I'm a trial lawyer. I practice here in Palm Beach County, and I manage our office. I'm a defense attorney. I have the honor, I guess, of introducing the stars of our program today, our 3 jurists that are here with us from the courts of our state. Those of us that are here are actually honored to have an audience with you. Because you guys, you girls, you kids will likely be in a position to follow us and to one day be sitting up here and doing things serving your community as these folks have done to serve theirs. I have to tell you, each one of them, Ms. Larson, myself, we too sat exactly where y'all are sitting. We went to schools in South Florida. We went to middle schools. We went to high schools, all here in South Florida. These jurists, each of them who went to schools in Florida, they worked hard. They served their communities. They engaged in extracurricular activities, and they made their way to college. They made their way to law school. They worked in law school, and they served their communities. They became trial lawyers. They earned a living. They raise children, they continue to work, and they ultimately make their way to the benches of our state. You should admire them. All right? You should appreciate them because they volunteer to be here. They're not required to be here. They're not getting paid to be here. They do it because they care, and they do it because folks like you will be running this country in the future. And so we thank them for their patience and for their efforts for being here to speak to you. For what purpose? Hopefully to motivate you, maybe to inspire you, to excite you. We all too sat in chairs just like that, guys. I could go through their resumes that are pages upon pages of accolades and successes, but I'm not going to do that. I'm going to tell you a little bit about each of them. They've heard this before, but trust me, they've worked hard since high school to do that which allowed them to be here. Our first judge today, Judge Simone Rowe, she is a trial judge. She actually sits on the bench here in West Palm Beach County Circuit Trial Judge. She's in what we call the civil division, so she deals with the administration of the law and handles trials involving injury cases or contract disputes or finances and things like that. She grew up in Palm Beach County. She went to middle and high school here. She made her way to the University of Miami. All right? She then went to law school at Nova Southeastern University. She was super active on the law review in law school. Like I said, and I'll continue to say, they continue to volunteer and involve themselves in all types of activities outside of just having to deal with the books. And so please consider that as you matriculate and grow through school. She worked as a trial attorney for many years, and ultimately she was appointed to the bench in 2016, I believe, by Governor Rick Scott. Next to her is Judge Schosberg-Fewer. Judge Schosberg-Fewer actually practices here in Palm Beach County too. She's a trial judge, but she sits in a different division. Our courts have different divisions. We got criminal, we have family, we have civil. Well, Judge Schosberg-Fewer is currently in the Family Probate Guardianship Division. She's a Florida native, went to South Florida Middle School, high school, Tufts University, ultimately made herself to the University of Florida, where she was very active in law school. She served her peers, she served her colleagues, she volunteered for numerous positions. She then worked as a prosecutor. She worked in the State Attorney General's office for the state of Florida. She was a trial attorney before she was actually elected to the bench in 2014. Sometimes the governor appoints judges. Most judges have to run for election. Judge Fewer still volunteers a ton and does a lot with youth, and if you looked at this resume, you'd see each of them are intimately involved with kids stuff, youth activities, civic, social. They're here because they care. Judge Connor. Judge Connor's been around longer than the young ladies that are with us. He too is a Florida native, Florida Middle School, Florida High School. All right, made his way to Duke University. Ultimately went to law school at the University of Florida, and he sits on our appellate court. We have 5 districts in the state of Florida. There's a whole bunch of circuit courts, but we only have 5 appellate courts in the state of Florida, and Judge Connor sits on the 4th District Court of Appeal, which handles appeals from courts like those that the other 2 judges sit on. They try cases. If some lawyer believes there's a mistake or there was error occurred, it goes before a group of judges like Judge Burton Connor. He served as a public defender. He served as a juvenile judge. He served as a trial judge in Indian River County, Okeechobee County, Martin County, before he was ultimately appointed to the appellate bench, I believe in 2011. We are super fortunate to have these fine folks here with us today. We truly hope you embrace this. Hope it makes you think about it. We need more good people like y'all to come to our world, and we hope you have a great day. Thank you, kids.
You guys are on.
And we're ready to rock.
What does the Constitution do? Well, it sets up the government, it defines the government, and it protects the basic rights of Americans.
So to compare what our country is from other countries, read that which is on this screen, and anyone can shout out, it's a constitution from another country. What country do you think that constitution is from? Anyone? Somebody said Canada. Anyone else? I can't hear you. Speak up. Don't be shy. England?
England.
England, all right. Somebody saw England. Anyone else? One more shot. Yes, ma'am. Korea. Oh, my goodness. You are actually right. It is the Constitution from North Korea. So let's look at that. It says citizens are guaranteed freedom of speech, of the press, of assembly, demonstration, and association. Now let's think about North Korea. Do you remember who the leader of North Korea is? Do you think he guarantees the freedom of speech, the press, assembly, demonstration, and association? Those are the words of the Constitution of North Korea. And as you have correctly pointed out, it's not embraced by the country of North Korea. We live in a country that embraces our Constitution and strictly adheres to the words that are put on paper.
Okay. Now, I think you already had a little bit of a heads up with the last slide, but take a moment and look at this. Everyone shall have the right to privacy of correspondence, telephone communication, mail, cables, and other communications. Everyone shall be guaranteed the freedom of ideas and speech. The freedom of the mass media shall be guaranteed. Judges shall be independent and submit only to the Constitution and the federal law. The Constitution Court, upon the request of the President, shall give its interpretation of the Constitution. Now, what Constitution do you think this is from? Anybody? Raise your hand. Or shout it out.
Shout it out.
You know it's not North Korea, right? Because we already had that one. So, South Korea. Someone said South Korea. Okay, no. Who else? What? Canada? No. England?
Somebody
Someone said China.
Somebody said China.
Getting there. Where?
France.
France. Japan, I heard. What else? Vietnam. Back there. Russia.
Russia.
Absolutely. Give that person a prize. Now, ladies and gentlemen, this sounds like something that would come from our Constitution that guarantees these liberties, right? But actually, it scores a 20, and you can see, I don't know if you can see this slide that well, but it scores a 20 out of 100, suggesting a rating that this country is not free, according to the Freedom House Freedom and World Report in 2017, and it rates the lowest possible score for political rights and the second to lowest for civil liberties. So sometimes things might be in countries' constitutions, but they actually don't have the strict adherence to their constitutions and the words that they say, different from what we do in our country. We do have a strict adherence to our Constitution, and we believe strongly in the freedoms, and that's why judges like us do our best to uphold those freedoms.
So you heard from Ms. Brock this problem about writs of assistance, and so let's talk a little bit about some of the considerations that were of concern when we decided to have this Constitution. And one of them was the court system. Back under the colonies, the jury trial was viewed as an instrument of oppression, and that was because judges could make juries stay until they came out with the right decision. So obviously that was a real concern, that it was oppressing people rather than trying to adjudicate what justice is. So let's talk a little bit about the U.S. Constitution and this concept of separation of powers, okay? So the Constitution provides for three separate branches of government, co-equal branches of government, and the separations of powers of these responsibilities is to prevent a concentration of power, because obviously under the colony system, the king was the source of everything. And by the way, this is how judges even came about. I mean, way back in the feudal days, the king was all of the law and had to decide disputes. Well, as things started growing, it got a little complicated, so the king had to come up with a way to resolve disputes between all these different other people living in the country, and he decided that he would appoint people to make decisions for him. And that's where we have this first system of judges. But judges definitely worked up under the king. So the structure is designed, this structure of a constitution is designed to prevent any abuses of power by one branch having too much power to control things. So a constitution is usually seen as a necessary predicate for democracy and the rule of law. And it's supposed to be a fundamental statement of what a group of people gathered together as a nation believe to be the basic rules and values that they all want to share and they agree to bind themselves to. So this idea that this is something that the people are binding themselves to, that's why the first words of the Constitution begins with, "We the people." So the Constitution serves as kind of like an architectural blueprint of the organization of institutions of government, but it's also the standard by which we gauge actions by the government. So one of the concepts that's embraced by this notion of Constitution is the rule of law. Anybody have any idea when we say the rule of law, any idea what that means? Any ideas? Yes. A little louder, please. Nobody's above the law. That's a very key component of the concept. You know, actually, the reality is scholars have a very hard time coming up with a kind of a concise definition of what the rule of law is. But I think perhaps one of the best definitions I've read is the following. The rule of law is a system in which there are 4 universal principles. Number 1, government and its officials and agents are accountable under the law. Number 2, laws are clear, publicized, stable and fair, and protect fundamental rights, including the security of persons and property. Number 3, the process by which laws are enacted, administered, and enforced is accessible, efficient, and fair. And number 4, justice is delivered by competent, ethical, and independent representatives and neutrals who are of sufficient number and have adequate resources and reflect the makeup of the communities they serve. One of the other fundamental concepts embraced by the Constitution, and it's been mentioned earlier in the discussion today, this notion of checks and balances. And probably one of the greatest strengths of our Constitution is the fact that it implements the rule of law, and our forefathers set up a brilliant system that's designed to have a series of checks and balances so that no one branch of government is too strong.
Now, wait, before we go to can you go back one slide? So I'm going to ask a question. So Judge Connor was just talking about the 3 branches of government. So I didn't want you to take a peek at the next one because I'm going to ask you, who knows what one of the branches of government is? Up here in the front. Executive branch. And do you know what the executive branch does? Enforces the law. So what's an example of a person who works in the executive branch? There's some people in here right now who are in the executive branch. Yes. In the back? Right there? You. Okay. I'm sorry, I don't know your name, but okay. Anybody in this section? Who is a person who works in the executive branch?
Call it out.
Call it out.
The
President. Absolutely. Well, we know that the president's not here right now, so what's another example of somebody who works in the executive? Police officers, exactly. So that's the executive branch of government. The executive branch enforces the law, and police officers and the president make up that branch. What about another branch of government? Anybody? Over here, this section.
The judicial branch?
Judicial branch,
Judicial
absolutely.
branch.
And what does the judicial branch do?
The judicial branch decides whether or not laws are fair and abide by the Constitution.
Exactly. We interpret and we apply the law, and we determine what is fair pursuant to the law. And obviously, you know, the judicial branch is made up of judges like us up here. Third branch of government. Over here. No, legislative branch. Yes. What does the legislative branch do? Makes the laws. And an example of someone who is part of the legislative branch is who? Can't hear you.
Representative or senator?
Representative, right. Senators, congressmen, congressmen or women, people who are in Congress, right? And so as Judge Connor talked about, we have this brilliant system of checks and balances that our forefathers created so that no one branch of government has all the power, so that everybody can make sure that everything is in balance, and that if one tries to take too much power, the other can take the power over and make sure that they're all equal. So you see the slide, make the law, oh, that's cool how that does that. Enforce the law, and interpret and apply the law. And those are kind of the three buckets.
So out of those three branches of government, which branch or branches protects the rights of the citizens? Any ideas? Yell it out.
Judicial.
All of them? I've heard judicial. Okay. Well, we have three branches of government, and let's talk about the role of the judicial branch a little bit more. Let's go back to that second slide, if we could, the previous slide with the three branches. Okay? So tell me, what's the difference between makes the law, which is what the legislature is supposed to do, and the judicial branch, which is supposed to interpret and apply the law? What's the difference between makes the law and interprets the law? Any ideas? Yes?
The difference is like they will like write, they have the ideas of the law, and then it goes to the executive branch who approves the law, and then after they approve the law, the judicial branch, like judges, they make sure that the law is applied to every person equally.
Okay, that's a good answer. So let me ask this. What's the difference between enforces the law, which is the function of the executive branch, and the judicial branch role of applying the law? What's the difference between enforcing the law and applying the law? Anybody have any ideas? Over here. Yes?
Applying it means that everyone has to follow it, and then the judicial branch kind of like interprets it to make it so it applies to everyone equally.
Okay. One of the things, if we could go back to that slide, one of the things you'll notice, the slide has three little short phrases to define or describe the function of each branch of government. And one of the interesting things is each of those phrases has the term the law. What is the law? Okay? Well, I would suggest to you, for purposes of this conversation today, the law is a written statement of a rule of conduct that can be enforced by a governmental entity. Okay? So when we say that the legislature makes the law, what we mean is the legislature enacts a statute. And in the federal government and in the state government, we have volumes and volumes of books of statutes that states all these rules of law. Okay? But here's the inherent problem. The legislature tries to string together a set of words to capture a concept of a rule of conduct. And the problem is, as human beings, none of us are smart enough to figure out how to string those words so that it will capture all the different instances where something can come up. Because a law is generally enacted by the legislature either because there is a problem that needs to be fixed, or they're anticipating a problem and they want to fix it before it ever happens. But again, the problem is when you start trying to string words together to figure out, to define what the rule of conduct is, it's very hard, and it's sometimes very difficult to figure out what do these words mean. So that is, I submit, the primary function of the judicial branch, is when these disputes come up between either governmental entities and the citizens, or between citizens themselves, about what the rule is, somebody has to decide that. And it's the judicial branch that has to then interpret and apply the law to resolve those disputes.
You're done with the slide?
Yes.
So the judicial branch was not designed to be a political or representative body. That was written by the rock star that Ms. Brock was talking about, Alexander Hamilton, in what's called the Federalist Paper 78, and that was written by that rock star in 1788. Does anyone know what that building is? It's a building in Florida.
Anyone?
We'll give you a hint.
To give you a hint,
It's in Tallahassee.
It's in Tallahassee.
Any ideas?
It's the capital of Tallahassee.
Yes, you get a gold star. That is the Capitol building in Tallahassee. That is where the legislative and executive branches meet and operate. The legislative and executive branch are elected officials, and they are to reflect and represent the people and respond to the issues and policies that the people that are impacting their various communities. At the legislative branch, you will see lobbyists, constituents, special interest groups, and the like. Judge O'Connor?
So let's talk a little bit about, again, judicial decision-making. And to understand a little bit about judicial decision-making, it's kind of important to understand our system, the court system in Florida and federally. So we've got a little video clip to show you to explain some of that.
Most people only know about the court system from what they've seen on TV. But our courts serve real people with real problems. Almost 90 million civil and criminal cases come before nearly 30,000 state court judges nationwide each year. In Florida, trial courts include county and circuit courts. Trial courts are generally where cases are heard by a judge for the first time. A judge presides and attorneys question witnesses and present evidence. In some cases, juries are selected to evaluate facts and determine a verdict. Each of Florida's 67 counties has its own county court, which hears cases including traffic offenses, criminal misdemeanors, and civil cases involving relatively small amounts of money. Florida is also divided into 20 judicial circuits. One circuit can cover one or several counties. Circuit courts hear family law cases, felonies, juvenile delinquencies, and dependency cases, and civil disputes exceeding the amount heard in county court. Circuit courts may also hear appeals in some cases from county court. Florida's appellate court includes the 5 district courts of appeal and the Florida Supreme Court. The district courts of appeal review decisions of the trial courts and hear cases not directly appealable to the Florida Supreme Court. Appellate courts do not retry the case again. Lawyers from both sides file briefs and may request oral argument. District Court of Appeal judges generally sit in 3-judge panels to review cases and determine if errors were made during the trial. The Florida Supreme Court, with 7 justices, is the highest court in Florida. The court reviews death penalty cases, constitutional questions, public utility cases, and more. The Judicial Branch interprets and applies the law, settles disputes, and determines if laws are unconstitutional. The Judicial Branch ensures your rights are protected. Judges and juries play a critical role in our courts and in our lives. For more information, go to www.justadulting.com. This message is provided by the Florida Bar Law Related Education Committee.
Whatever. So it's very important when we adopted the Constitution and developed our system of government that we make sure that there would be a right to appeal if you've got an adverse decision out of the trial judge as part of that checks and balances system. So I wanted, the video did a pretty good job of explaining the difference between an appellate court and a trial court, but I want to hit one of the points a little bit in more detail, and that is the 3-judge panel at the appellate court has basically 2 functions. First, we have to decide when an appeal is filed, what the person is saying, and everybody in the state of Florida, if you lose in the trial court, you automatically have a right to appeal. You don't have to, and a lot of people don't, but you have an automatic right to appeal, okay? And when you appeal, what you're saying is the trial judge did something wrong. Either the trial judge let evidence in that shouldn't have come in, or kept evidence out, or didn't follow rules of procedure, didn't instruct the jury correctly, or whatever. The trial judge did something wrong. And so the three-judge panel has to first decide, did the trial judge do something wrong? And trial judges, God bless them, they've got a lot of work to do, and it's a tough job, and they're human beings, and sometimes they do make mistakes. But if they did make a mistake, the second and more important question is it bad enough for a redo? In other words, do we say, okay, you got to go back and do it over again? The important thing about the appellate court is we have to take the facts as they were found by either the jury or the judge. We cannot make any factual determinations. So when we have a case argued in front of us, we don't have witnesses come in and raise their right hand and swear tell the truth, or we don't, base our decisions on what we believe we would have done if we were the trial judge looking at evidence or whatever. We have to accept the findings by the trial judge, and our decision is, did the trial judge properly apply the law to those facts? One more thing I want to talk about, though, is this jury trial system, because ABOTA is the best organization I can think of that helps promote this concept of a trial by jury. And if you take nothing else away, I would ask that you please, when you turn 18, or even before you're 18, discuss it with your parents and your family and your friends. If you get that jury summons, don't ignore it and don't try to get out of it, okay? Because what makes us the greatest republic of all times is the fact that we have this right to a trial by jury. Because here's the concept. The concept is we trust everyday citizens to come in and we give them jury instructions at the end of the case. These are the principle of laws. They actually get a written set of the instructions to take back into the jury room, and then we ask them to decide what the facts are and apply the law. So when I used to sit in the trial court and I would dismiss jurors at the end of the case, I would say to them, I'm sitting up here in the black robe calling the balls and strikes, deciding matters of procedure and evidence, but you had to do the heavy lifting. You're the ones who had to decide, what do these words mean and how do they apply to a set of facts? And America there are a lot of countries in the world that have the right to a trial by jury, but it's criminal cases mostly. America offers the right to a trial by jury in civil cases, and we offer the right to trial by jury more than any other country in the world, and that's what makes us the greatest republic of all time, because we trust citizens to act as judges. One of the functions of government is to resolve disputes, and that's how we all live peaceably. And we trust citizens to come in and help resolve those disputes. So when you sit on a jury, you are performing the function of government by resolving disputes. You're not voting for somebody to do it. That's where the rubber hits the road. You are actively participating in your government. So don't try to get out of jury duty.
And just to echo what Judge Connor was saying, and when I have jury trials, I tell people that it's a small price to pay for the liberties and the freedoms that we have in this country. You get called once a year, and we get questionnaires after jury trials from jurors, and 99.9% of them say, I was so proud to have served, I could see the justice system in the works, and I could be part of that system. So, just if it was a trial for you, whether civil or criminal, you would want a jury of your peers, unbiased people, sitting there as the fact finder determining the outcome of cases. So I echo Judge Connor's sentiments exactly. When I speak to students, I say, if you only remember one thing, please, when you get your summons, there's two prices we have to pay. One, paying taxes, and two, jury service. So please, when you get your summons, come to jury duty. It's actually a very interesting process, and the system works.
Just to, again, dovetail both Judge Connor and Judge Fuhrer, I tell the jurors that come before me, in fact, I just had a jury trial that ended yesterday, you are judges. The state of Florida just can't afford robes to give you as jurors to be judges. And another sort of war story that I tell, I had a trial once where we were picking the jury, and a lot of people want to get out of jury duty, and this one lady ended up being picked, and she literally cried from the veneery. There's a place where the jurors that are prospective jurors sit, and then you walk over to the cushy chairs, as I call them, where the jurors actually sit and preside, she literally cried on that process. And she ended up being the foreperson of the jury, and she answered a questionnaire, and she put in her questionnaire, everyone should have that responsibility to sit on a jury, because it was the most important event that she had ever had. So I strongly encourage you, whenever you get that jury summons, I promise you it's not going to be the worst thing in your life. You will learn something. You will get to be part of the system. You are the fabric of the Constitution. You are part of our judicial system. So applaud and appreciate the summons to be part of the system.
Before we leave juries, let me make one other point too, and that is a lot of times some people will complain about jury duty, the fact that they show up and then they never get to the courtroom, and it seemed like it was a waste of time. But we always explain to them, no, because you got to understand, a lot of times when the jury venire shows up for jury selection, that's when cases settle, either on the criminal side or the defense side. So again, just by showing up, you're performing a function of government, because disputes are getting resolved, because people are settling their cases at the last minute, because they know a jury's about to come in and make that decision, and they decide, okay, let's settle this thing. Okay. No vehicles allowed in the park. That's a rule. That's a statute. Just got enacted. What's it mean? Any ideas? What's it mean? Yes?
Okay. It means that no, motor vehicles are allowed in the park, but it's very vague when you say no vehicles are allowed in the park, because what about bikes or strollers? Because they're on wheels too, and they're basically a vehicle, if you think about it. Well,
See, you just pointed out the comment I made earlier about this notion of stringing words together to try to state a rule of conduct, because you said motor vehicles. I don't see the word motor in that string of words at all. So, does it include a bike? Does it include a motorized wheelchair? I don't know. Yes?
But there's an exception, because you can have police officers, they can actually go and take any government, a garbage truck can actually go into the park, because those are allowed and those are exceptions.
Okay, so now we're allowing garbage trucks, and are we going to allow ambulances? What if somebody drops over in the park? Are we going to allow? So, but again, there's nothing in there that says, it says no vehicles, okay? And the legislature might have said, well, we need to kind of keep things broad, because there could be all kinds of things. And no, we don't want these motorized bikes in there, or we don't want bicycles at all. And so we need to choose a word that's kind of broad. But somebody made a comment in answering the question that gets to, again, part of the heart of the problem. It's almost impossible. I defy anyone in this room to be able to come up with a rule that does not have an exception, okay? There's always exceptions. And then the problem is, how do we draw that line for the exceptions? Okay? So take a look at that slide. She says, I always thought it's weird that they say a defendant is innocent until proven guilty. And he says, weird? What's weird about it? She says, well, technically, a defendant shouldn't be considered innocent unless he's proven guilty. And he says, I never really thought about it that way, until makes it seem like a finding of guilt is inevitable. And he goes on to say, it's a fine distinction, but an important one, and from now on, I'm going to say innocent unless proven guilty. And I got to tell you, as much work as I've done as a lawyer and as a judge, until I saw that slide, that had never hit me before. And as an appellate judge, let me explain one other difference between what I do and what the trial judges do. The trial judges will come out with a decision, and in the end, they typically will sign a written judgment that ends the case, okay? Comes to our court, and if we decide to either affirm or reverse, in a lot of times, we have to write an opinion. When they write something that's a final judgment, it's going to go in a court file, and yes, it's open to the public. Anybody can walk into the courthouse and go look at it, but that's pretty much where it's going to stay. Whereas when at the appellate court we write an opinion, it's going to go in the law books. And the law books are something that are published online now, so that judges and lawyers can look at what the appellate decision is. So it has a much broader impact. And again, at the appellate court, we face the same problem that the legislature does, because What are we doing? We're stringing a bunch of words together to come out with a decision. And we have to be very careful. Probably the thing I appreciate the most, having been an appellate judge 8 years now, the big difference is I have to be so much more precise in the way I string words together. Precision is everything, precision of thought and precision of words. So words do matter.
To follow up with what Judge Connor just said, that words do matter and the Constitution requires interpretation. So take a look at that. Does anyone know what part of the Constitution that is? It says, Congress shall make no law abridging the freedom of speech. Anyone? Shout it out.
The First
Amendment.
Amendment.
Amendment, exactly. Now, back in the 1700s, when this Constitution was written, speech was words on a piece of paper. But what is speech? What does speech mean? There's now Twitter. Is that speech? What about Facebook? What about my technology, social media is not so good. What else is there? Instagram. What about Instagram? Is that speech? All right. What about an email? All right. All of those were not necessarily contemplated when the Constitution was written, but it required interpretation as time went on to determine whether or not those forms of words actually constitute speech. Let's take a look at another one. That one says protection from unreasonable searches and seizures. It doesn't say and, it should say and. Where does that come from? All right, everybody knows that one. Awesome. Well, what does unreasonable mean? Well, Ms. Brock started out when she was talking about Mr. Otis. People were just randomly going in the house, right? Isn't that what you were saying? Is that reasonable? Can you just have somebody just say, look, I want to go look inside your house. I'm a law enforcement officer. Is that reasonable?
Well, no, wait. The king said, I got to make sure that, the law is being complied with. So why isn't it reasonable to make sure that the king's law is being followed?
We don't.
Well, but let's say the legislature passes a statute and it makes something illegal. Why shouldn't we be able to search wherever law enforcement thinks there might be some illegal drugs or contraband or weapons or whatever?
It's an invasion of privacy.
Well, that's right.
And do you remember what she said in the beginning? Ms. Brock said, a person's home is their castle, right?
But that's a very interesting concept, this notion of privacy, because I got to tell you, I'm an old guy, and I'm not as up on this techie stuff that young people are, but everything's being captured now. So what is this concept of privacy? It's tricky sometimes.
All right, this one says, no excessive fines imposed nor cruel and unusual punishment inflicted. Oh, you guys won't even let me finish. You're ready for this. That's awesome. Yes, it's the Eighth Amendment. So what is excessive? What does excessive mean? Anyone? Tell me what's your interpretation of excessive. Pardon me? Too much. What about cruel and unusual? What does that mean?
Abusive.
Inhumane? All right, back, I don't remember one, Judge Connor may be able to remind me, but back in Florida, there was a time where the state of Florida could put minors to death.
Yes.
Someone under 18 could actually be executed. Is that cruel and unusual? That's right. The U.S. Supreme Court said so. They interpreted the Constitution as it related to a Florida law that allowed minors to be executed, and the U.S. Supreme Court said that was cruel and unusual punishment, so no longer do we execute minors.
But let's think about that for a minute, because there were statutes that said, yes, you could execute someone who committed a capital murder and did not make any distinction between whether they were under 18 or not. And so our elected officials The legislature passed that, and that was the will of the people. So why is that unreasonable? If that's the will of the people, why is that unreasonable?
Anyone?
Because the Constitution always trumps statutes, okay? And as Judge Rowe just mentioned, the United States Supreme Court ultimately, for a number of years, they said, yes, this is okay, but they ultimately decided, nope, this is unconstitutional. This is no longer allowed, and states cannot pass statutes that allow for that.
And part of the reason, just to jump in for a second, was they did this entire analysis about how juveniles' brains are not fully formed until they're 21 or 23 years old, and that was part of the analysis of excessive fines and cruel and unusual punishment.
All right, let's go to the next one. Nor any state deny to any person within its jurisdiction the equal protection of the law. Does anyone know where that comes from?
10th.
All right, 14th. Who said it? All right, you got it.
Good.
Now we're going to talk about this a little bit more in some future slides, but what does it mean to treat people equally? Pardon me?
It means that everyone's...
I'm sorry, I didn't hear you. Having everybody has the same rights. Yes, ma'am. Religion. There's
ethnicity.
Ethnicity.
All right, so as you can see from these slides, there are some words within the Constitution that actually require interpretation. Cruel and unusual, what is reasonable, what is speech. There are other aspects of the Constitution that really doesn't require a whole lot of interpretation. For example, part of the Constitution says what the minimum age is for the President of the United States. There's really not a whole lot of interpretation that's required to determine what the minimum age is for the President of the United States. But there are aspects of the Constitution that does require judicial involvement for a judge to actually interpret and apply the law to the facts. As Judge Freer had said, the facts of the case when the U.S. Supreme Court decided that it was cruel and unusual, they had a whole lot of facts to determine what is part of the juvenile, what comprises a juvenile, and should a juvenile be treated the same as someone that's 40 or 50 years old who committed potentially the same crime. So that's where the judges come in. Now we're going to talk a little bit about the court system. And that's where judges come in. Judges have to make difficult decisions according to the Constitution that may not be popular. Now, the whole three branches of government are supposed to be working cohesively. And sometimes the judicial branch has to disagree, as with the legislature in Florida, with the legislative branch concerning the cruel and unusual part. That's not an easy decision generally for a judge to make, because now they're sort of disagreeing with, a co-equal branch of government. And judges generally have to do that. We have to be independent. We cannot be influenced by public opinion, by public sentiment, and the like. So I'm going to talk about actually I get to talk about two of my favorite cases. And they're two of my favorite cases because not only does it show an example of judges making difficult decisions, it's personal to me. One of the cases is Brown v. Board of Education, and that's a case that came down from the U.S. Supreme Court in 1954. Back then, there were a third of, I'm going to give you about 10 facts concerning Brown versus Board of Education. Back then, in 1954, a third of the U.S. was segregated. 17 southern states had segregated schools. That means that the people that you're sitting next to didn't look like the person sitting next to you. Blacks could not go to school with blacks. Whites went to school blacks could not go to school with whites went to school by themselves, and they had a concept separate but equal. That was the concept by which they determined that we could have segregated schools. They were going to have separate schools, but they considered those separate schools equal schools. Brown versus Board of Education involved 5 states. So 5 states were involved in this U.S. Supreme Court decision: Kansas, South Carolina, Virginia, Delaware, and Washington, D.C. had laws on the books, separate but equal. They had segregated schools. And individuals from each of those states sued their state, saying that separate but equal was not equal, and they wanted to have integrated schools. One gentleman, Mr. Brown, who was a laborer, his daughter had to walk 7 miles to school when there was a school just a mile away that his daughter could be educated at, but it was a white school. It was a white-only school, so his daughter could not go there. So Mr. Brown sued and went to the state Supreme Court, and they enforced that law. They enforced the separate but equal law. Many of those folks suffered hardship by taking these cases to court. Mr. Brown lost his job. There was another person from another state who was a preacher. His church was burned down because he wanted to have an equal access to education. This case introduced us to the first African-American U.S. Supreme Court Justice, Thurgood Marshall. He was part of the NAACP, and he represented those individuals at the U.S. Supreme Court. He was supported back then by the Department of Justice, because the Department of Justice also was supporting supporting the integration of schools. The president at the time, who was also part of the executive branch, because the DOJ is part of the executive branch, disagreed with the DOJ. So there's an instance where there are 2 members of the same branch of government that disagreed with each other. The case went to the U.S. Supreme Court, and 9 white males determined that separate but equal was not equal. And they struck down those laws in those 5 states, requiring the 5 states to integrate the schools. Those justices, the Chief Justice who wrote the opinion, Justice Warren, they wanted to impeach him after he rendered that opinion, because many of the people that supported segregation did not like that opinion. He had to essentially buck the system because they did not like the opinion that he wrote. So judges oftentimes have to make very difficult decisions. And the reason we all are able to go to school together now is because of Thurgood Marshall and Brown versus Board of Education, and that's the reason I'm here. So that's one of the reasons why I really like this case. The next case that involves making difficult decisions is another one near and dear to my heart. It's called Loving versus Virginia. This is a case that came out of 1967. There's actually a movie that memorializes this. So if you ever want to Google, Loving is the name of the movie, and it sort of recaptures this love story. It really is a love story. It's interesting that their name is Loving, and it truly encapsulates a love story. Back then in 1967, 16 states had anti-misogynistic laws, which means laws that prohibited people from different races to marry. Back then, they equated interracial marriage with polygamy and incest, which is why they outlawed it. But Mildred and Richard fell in love. Richard was a Caucasian man. Mildred was half African American and half Native American, and they fell in love. They lived in Virginia. They lived in Virginia their whole life. Virginia had one of that anti-misogynistic laws, so they couldn't get married in Virginia, so they drove to D.C. and they got married. They got married in D.C. and came back to Virginia because that's where Mildred's family was, and Mildred she's kind of like a homegirl. She wanted to be close to her family. About 7 weeks after being married, the police came and arrested them in their house and convicted them of this crime. They didn't sentence them to jail, but they banned them from the state of Virginia. So they had to move out of the state of Virginia for 25 years. Mildred she loved her family. She wanted to go back to Virginia. She wrote to the Attorney General, Robert F. Kennedy, about her story, and Robert F. Kennedy referred her to the ACLU, who took her case. And they went to the U.S. Supreme Court, and again, 9 justices unanimously decided that love is love, and there should be no prohibition to a person marrying a person that they love. And I am a product of that as well, because if I did not have Loving versus Virginia, I could not marry my husband. So that's another reason why this case is so personal to me. That case gave birth to another case, Obergefell, I always mispronounce it, versus Hodges, in which the Supreme Court, in a 5-4 decision, found that same-sex marriages were also legal. So these are cases in which the courts had to struggle with a difficult decision, laws that were relatively popular in the states that they were enacted, but the Supreme Court said no, that those laws were unconstitutional, and that is the 14th Amendment. That's the application of the Equal Protection Clause, and that's how the U.S. Supreme Court came forward with their decision.
Okay, I'm going to talk about the famous flag burning case, Texas v. Johnson, which was from 1989. And I'm going to do a little exercise with you guys. I want to know, for the people who think that you can burn the flag, I'm not saying you should, but that you can burn the flag under the First Amendment, please stand up. Stand up. Okay. There's a lot of people over here. There's some consensus building. Okay, sit down, please. Now, what about people in the room who think that you cannot burn the flag under the First Amendment? Come on, don't be shy. Don't be shy. Okay. And then, please sit down. Now, who's undecided? Stand up. Anybody undecided? It's okay. There's a lot of gray areas in the law. It's okay. All right. All right, so you guys can sit down. So remember, Judge Rowe went over, Congress shall make no law abridging the freedom of speech. So Texas v. Johnson. Gregory, I'm going to give you a little synopsis of the facts. Gregory Lee Johnson burned an American flag outside of a convention center where the 1984 Republican National Convention was being held in Dallas, Texas. Johnson burned the flag to protest the policies of President Ronald Reagan. He was arrested and charged with violating the Texas statute that prevented the desecration of a venerated object, including the American flag, if such an action were to anger or likely incite anger in others. A Texas court tried and convicted Johnson. He appealed, arguing that his actions were symbolic speech protected by the First Amendment, and the Supreme Court agreed to hear the case. Now, the issue, of course, is whether flag burning constitutes symbolic speech protected by the First Amendment. Now, the answer is yes. You can, under the First Amendment, burn the flag. And the majority of the court, according to Justice William Brennan, agreed with Johnson, the person who burned the flag, and held that flag burning constitutes a form of symbolic speech that's protected by the First Amendment. The majority noted that freedom of speech protects actions that society may find very offensive, but society's outrage alone is not justification for suppressing free speech. And Justice Anton Scalia, and I think this is on one of the slides, yes, said, if I were king, I would not allow people to go about burning the American flag. However, we have a First Amendment which says that the right of free speech shall not be abridged. So that's an example about how judges' personal opinions cannot be involved in their deciding of their cases. Now I want to talk about another case that's not on the slides, but it's also a case that deals with the First Amendment. This is a case, Morse v. Frederick, from 2007. I'm going to tell you a little bit about the facts. At a school-supervised event, Joseph Frederick held up a banner with a message that said, "Bong hits for Jesus." And this is a slang reference to marijuana smoking. The principal took away the banner and suspended Frederick for 10 days. And the principal justified her actions by citing the school's policy against the display of material that promotes the use of illegal drugs. Now, Frederick sued, alleging that this was a violation of Okay, I'm sorry, of the First Amendment. Now, the question was, does the First Amendment allow public schools to prohibit students from displaying these types of measures, promoting the use of illegal drugs at school-supervised events? And it said yes. The court said by a 5-4 vote, ruling that the school officials could prohibit students from displaying these messages because they promoted illegal drug use. And so they found that this was not First Amendment protected.
We're getting a little short on time, but let me just ask, so what would happen if judges made their decisions based on either public opinion or special interest or political influences? What do you think that would be like if judges did that?
It would lead to some form of despotism on the half of the judicial branch.
Despotism, I love that word.
Yeah, that's good.
Ooh, I love it.
I saw a hand over here. There was a comment over here. So, yes. Certainly, this concept of checks and balances would start to break down. So let me ask this question, because we talked about 3 controversial cases that have been decided by the court, and we've talked about 3 branches of government. Which branch of government is the strongest? They're supposed to be co-equal, right? Well, let's think about this a little bit more. As far as the legislature is concerned, they have what's called the power of the purse. They're the ones that decide how the tax dollars all get spent. So if the president decides he wants to do something, Congress can kind of check him and say, you know what, we're not giving you any money. Now, the president can have the power of the military, right? I mean, he's got guns and bullets and stuff, and he can certainly wield a lot of power. So let's say that Judge Rowe says at a hearing, Sheriff, I want you to arrest this man, or issues a warrant or whatever, and the sheriff goes, what happens? I mean, he's got the guns, she doesn't. However, I would submit to you that it's actually the judicial branch which is the strongest branch of government. Do you know why? It's not because of brute strength and bullets or whatever. It's not because of money. It's because we adhere to the rule of law, and it's the importance of doing the right thing that trumps in the end. It will beat bullets, and it will beat money, doing the right thing, and that's what the judicial branch is designed to do, is to make sure we adhere to the Constitution, we do the right thing, and we don't give too much power to anyone, because we could end up with
Despotism.
Despotism. I love it.
So when you walk into a courtroom, what do you want to see in the judge? What are some of the characteristics you want to look for? What do you think? Yes?
I would hope that they're dressed like professionally and they come to work like not tired and they're ready to do their job.
All right. What else? What else do you want to see with a judge?
Confidence.
I would like to see a smile on his face, because that makes you feel like more comfortable if you see smiling.
Okay, we'll come back to that in a minute. I heard
somebody said competence.
Competence.
Who said competence?
Competence or confidence?
Unbiased.
Unbiased, okay.
Impartial.
Impartial.
He has like a serious face on, so it means that he's ready.
Somebody said serious face, somebody said smile on their face. What should my face look like?
Yeah.
I'm not sure.
You have to make a lot of faces.
Doing that.
Because there is this thing called judicial demeanor, where judges are supposed to, because of the dignity of the law, they're supposed to have a certain appearance or whatever. So some other things you look for in a judge. Yes?
Someone that looks older, like experienced, so that they know what they're doing.
That's an interesting concept.
Being determined. Being determined.
Being determined.
Being determined, okay.
Compassionate.
Compassionate.
Organized.
That might kind of go with a smile once in a while, I think, yeah. What else?
Organized.
Organized.
A judge who looks on both sides of the law. and who presents arguments on both sides, and not when the political opinions don't matter, they back up their evidence by both sides of the law.
I think what I'm hearing there is kind of a combination of keeping an open mind and being willing to listen to both sides before making a decision.
Yeah.
Does that make sense?
As
Yeah.
my friend Matthew said behind me, I think it doesn't matter what they look like. It just matters on how unbiased they are.
Okay, that's good. Yes.
Making an introduction, saying who they are, what's their name.
Okay. Yes, in the back there. Straight to the point. Okay. These are all good answers. Yes. Efficiency and that kind of thing. It's interesting, I haven't heard yet the word honest. Honest, I haven't heard
The judge's
that.
integrity.
Integrity, that's good, fair. Okay. All right, so what are some of the characteristics you don't want to see?
You don't want to judge.
You sure?
Them being racist.
Good answer. Because actually, that's another thing that I didn't hear when we were talking about what do you want to see when you walk in the courtroom. Hopefully, we do want to see some diversity on the bench. Yes?
You don't want to see somebody that looks like they're about to fall asleep in the middle of a case or something.
And before we move on from the topic before about the diversity on the bench, don't we want judges that look like our community, right? Women, men, different races, different religions, old, young. We want the bench to look like our community. There was a time not so long ago where there were only men on the bench, right? So, and exactly, someone said white men. So it's important for the bench to be diverse.
And let's go back to juries for just a minute, though, because again, that's that concept. It's collaborative decision making. It's 6 people from the community coming together, trying to answer a question or whatever, and it works best when you have a cross section of the community, people from different backgrounds and viewpoints looking at a problem, trying to solve it. Yes, sir.
A judge to be able to do things efficiently with little to no error.
That's tough.
We hope.
Go ahead, put the pressure on. That's fine. That's fine.
What about being humble? Don't we want our judges to be humble, or do you want them to
Be arrogant.
Right, be arrogant or wield
I know
power?
it all. You want a judge that knows it all? I'm not sure what I'm hearing. I'm hearing a lot of people discussing things.
Judges on the panel, maybe this is a good time to talk about. I hear some mumbling over here. Do we want judges to know it all? As judges, obviously you are highly credentialed and educated and intelligent, but are there times when you have situations where maybe you don't know the answer, and what do you do?
Oh, well, yeah, definitely. On my bench, you can't see it, it's for me. 3 phrases: be kind, be strong, be humble. If you don't, I believe that and I know my colleagues on the bench agree, we don't know everything. And that's why we rely on the attorneys or the litigants to present us with the facts and sometimes the law, because sometimes there may be a new area of the law, or Judge Connor has issued a new opinion. So we invite the litigants and the attorneys to tell us their client's side of the case and the law that supports the position in an honest way, and then we will make the determination, because the best thing about our jobs and the only requirement from our jobs is we want to do the right thing every day. Absolutely. And in order to do the right thing every day, we need the help from you all to give us the facts and the law to help us do that.
And that's why we have this adversary system of justice, where there's a plaintiff and a defendant, so that attorneys can come in and advocate for each side and point out different things from different viewpoints about each side, so that the judge can then apply the jury can apply the best information to come out with the best decision.
And I would also say this doesn't only apply to judges. You're only as strong as knowing what you don't know, right? So if you don't know something, and I have no problem doing this, you know what? I don't know the answer to that. I'm going to reserve ruling, and I'm going to get back to you, and I'm going to find the right answer because I want to come to the right decision. But it would be impossible for every judge to know every single, I mean, that's why they have tons of rule books, and, you know, we go to conferences, and we have judicial education, and we keep up on the new cases that are coming out. But you have to rely on the lawyers, and then you go back to your chambers and you do your own research and you figure out what the law says, and then you write your order or you deliver your ruling.
So what let's do Judge Connor.
So what, back to the question, what do you not want to see in a judge, and what should not influence a judge's decision?
They need to apply the law equally.
I'm sorry?
They need to apply the law equally no matter what.
Okay. But what are some of the factors or influences in our society that you don't want to impact the judge's decision? In the back there. Race?
Opinion.
Public opinion, yes.
Using their personal experiences and making their decisions.
You don't want their personal viewpoints. The judges have to look at the big picture, and I can tell you, and I'm fairly confident my two colleagues up here as well agree, there are any number of times I've had to make a decision. I felt like it was the right decision of the law. It's not the decision I wanted to make, but I had to do it because that's what the rule of law is all about. Nobody's above the law. You got to go by the law. That's got to be what guides you, is the law, not your personal opinion.
To follow that, I think it's Justice Scalia that said something to the effect of, he knows a good judge when they make a decision not based on what they thought they were going to rule on, but based on what they ended up finding as they started to do the research and the like. That's the mark of a good judge, a person that's willing to sort of change their initial thinking to follow exactly what the rule and the letter of the law is.
And not only that, but just to dovetail on that, as a judge, you have to be willing to make decisions that are unpopular, that are wildly unpopular. And we can't be influenced by the media. We can't be influenced by our personal opinion. We have to follow the law.
Being gender biased, like making your decision based off them being a female or a male.
It's true.
That'd be absolutely wrong.
Was someone back there?
The political background and NRA.
That's interesting that you say that, because judges cannot have a political viewpoint. We can never, as we sit on the bench, espouse whatever any political viewpoint. We cannot have one and that's sort of baked into the system, because we don't want people to feel as though we're not going to be fair and impartial because we have a particular political opinion. So we have to put aside whatever political opinion or whatever political leanings that we may have, because our only focus, our only job, our only role is to fairly apply the law to all individuals. That's what our role and our focus is.
And that's why we can't go to any political events. And it makes sense, right? I mean, would you want to come before a judge that was politically leaning one way or the other? Judges have very, very strict rules on what we can and can't do. We can't come out and publicly have an opinion about how we feel about guns, because what if a case comes before us that involves a gun and involves, someone's right to bear arms, or a stand your ground case, self-defense case? Our personal views cannot influence our decisions, and we can't have any of these public views that might make people who come before us, litigants, feel that we're biased.
So trial judges in this state are elected by popular election. In other words, somebody can decide to run against a judge and try to knock them off the bench or whatever. At the appellate court, I used to face that possibility, but now it's merit retention, where every 6 years the voters will decide on the ballot, yes or no, should we keep Judge Burton Connor. But somebody can't announce that they're going to run against me. But as to the two trial judges up here, yes, somebody could announce and run against them. And when that happens, it's a very different political campaign compared to the sheriff or the legislature or school board member or whatever, because judges, when they're campaigning, and lawyers who are trying to get elected, they're not allowed to talk about their views on controversial issues because, again, you want judges who are open-minded. So it's a completely different aspect when you're sitting there in the ballot box and you're voting on a judge, and the ability to get information to decide should I or shouldn't I is a little bit different than the other candidates on the ballot.
So we have some Kahoot questions.
Got your phone?
Take out your cell phone.
Everybody know about Kahoot?
This is one of those times where cell phones are appropriate in a class setting.
We're going to find out what you guys learned today.
See, they didn't bother to tell you there was going to be a test.
I know, despotism.
Despotism's going on the next one.
We have our first question. Do we have the login information? Can we turn that off for a second? Can we
pause it?
Can we pause this for a second, please? Do we have the login information? Ms. Brown, Dr. Johnson? Okay, she's getting it. There we go. There we go. 551157. 551157.
There's everybody.
See how quickly they got on
You
that?
have to put your name in there, okay? Because there may or may not be.
I know, look at
She said we're ready.
All right, here's our first question. I can't read it. Here's our first. Name the 3 branches of government. This should be easy. I can't see either.
Name the 3 branches of government.
So the square is Democrat, Republican. I gotta go. Ms. Brock, do you know? Thanks.
Okay, can y'all hear me? Shh, 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 shh. I'm going to read them off to you, okay? The red triangle says Democrat, Republican. Oh, right.
They're out of time.
Timed out.
They timed out.
Okay, we'll do it for
All
the
right.
next slide. All right.
All right, question 2. Branch of government reviews and explains the law, decides the law,
Is constitutional.
is constitutional.
Red triangle judicial, yellow circle executive, blue diamond legislative, green square none of these.
You have 7 seconds.
Time out.
All right, yay.
Everybody should have known the judicial branch.
All right, question 3. Prevents one branch of government from becoming too powerful.
Red triangle checks and balances, yellow circle War Power Act.
Listen.
Blue diamond law and order, green square none of these.
9 seconds. Who said checks and balances?
All right. Me either.
Good job.
All right, question 4. What year was the Constitution written?
Red triangle 1776, yellow circle 1791, blue diamond 1787, green square 1800.
The answer is 1787. Ooh.
Hard one. was a hard one.
I gave you that answer in
She
my
did.
opening.
Miss Brock gave you that answer at the beginning. All right, question 5. The Founding Fathers wrote the Constitution when they gathered in 1787.
Red triangle, Philadelphia. Yellow circle, Washington, D.C. Blue diamond, New York. Green square, West Palm Beach.
5 seconds. Yeah, good job.
Good job. All right, question 6. What does the Constitution do?
Red triangle sets up the government. Yellow circle limits the powers of government. Blue diamond lists some of our rights. Green square, all of the above.
All of the above.
All right, question 7. The idea of self-government is in the first 3 words of the Constitution. What are they?
Red square,
Judge Connor said
four
it.
score end. Yellow circle, oh say can. Green square, we the people. Yellow, blue
Settle
diamond,
down,
we hold
everybody.
these.
Settle down.
Hint, hint, Judge Connor said it during his speech.
We the people. Good work, everybody.
Question 8. How many justices are on the U.S. Supreme Court?
Red triangle 7, yellow circle 10.
Think
blue
about Brown
diamond,
versus Board of
9,
Education.
Green square 12.
Get this one right.
I know. Think about Brown versus Board of Education. All right, question 9. Who is the newest member of the U.S. Supreme Court?
Red triangle, John Roberts. Yellow circle, Brett Kavanaugh. Blue diamond, Sonia Sotomayor. Green square, Clarence Thomas.
Keep it down, everybody. Keep it down.
Ooh.
Still a majority. Still majority made it.
Next question. What is the meaning of the rule of law? Judge Connor talked about it.
Red triangle, society governed by men, not laws. Yellow circle, federalism. Blue diamond, search and seizure. Green square, no one is above the law.
All right. Good
All
work.
right. Huh?
I'm not sure.
What 2 rights are guaranteed by the First Amendment?
Red triangle, speech, assembly. Yellow circle, press, privacy. Blue diamond, petition, taxes. Green square, religion, due process.
Think about flag burning. Very good. Good work. You guys listened.
Amendment guaranteed right, due process, and equal protection under the law of
To all citizens.
To all citizens.
Excuse me. Red triangle, 14th. Yellow circle, 15th. Blue diamond, 6th. Green square, 21st.
Some powers belong to the federal government. Name 2.
Red triangle, support the economy. Comb beaches for gold. Yellow circle, declare war. Invade privacy. Blue diamond, make treaties, coin money. Green square, none of these.
It's kind of like a bonus question.
It's a hard one. Very good. Make treaties. Coin money.
Next question. During the 1960s, what movement in the United States tried to end racial discrimination?
Red triangle, women's rights. Yellow circle, civil rights. Blue diamond, Dr. Martin Luther King Jr. Green square, none of these.
Civil rights.
Ooh.
Last question coming up, everybody.
What is the legal voting age to participate in the United States presidential election?
Red triangle, 15. Yellow circle, 21. Blue diamond, 18. Green square, 25.
All right.
Here we go. Good work.
Right.
We have a winners.
Thank you, everyone.
Yeah.
Let's have a round of applause.
I would like for you guys, if I can have your attention, please. See, judges don't know to do this to have you instantly. I'm not in the classroom either, so when I do get to do this, I have a good time with it. So thank you guys so much. I hope you enjoyed all of the information that our panel of judges shared with us. If you enjoyed it, can you clap your hands? Awesome. So before we leave today, we do have some other presenters for you. I would like to bring up to the front one of our very own here. So here in the school district, we also have our own legal department. And so one of our senior counsels, Ms. Jean Marie Middleton, if you would please come on up. And Mr. Chio Reed from the F. Cunningham Bar Association. I have mics here if you need one.
Good morning.
Good morning.
That last question was a good intro to what we're going to be talking about. As she said, I'm Jean Middleton. I'm one of the past presidents of the F. Malcolm Cunningham Bar Association. We're going to talk to you about one person, one vote. So in 1776, with the signing of the Declaration of Independence, the right to vote was granted to only one group of people: white men who owned property. They had to be at least 21 years of age to be able to vote. At that time, as you can imagine, that would have been a very limited number of people who are voting on all of our laws. Later, in 1856, the United States became the first nation to expand the vote to men regardless of property ownership. So now you didn't have to own property, but you still had to be 21 and you still had to be white. Obviously, again, that didn't include a lot more people. So it wasn't until 1870 that non-white male citizens were granted the right to vote in the 15th Amendment. It declared the right of citizens to vote, but it shall not be denied by any state due to race, color, or previous condition of servitude. Again, those who were allowed to vote felt threatened, and there were a lot of discriminatory things that even kept people from being able to vote, even though they had the right. There were things like tests that they had to take, they had to go to different polling places, things of that nature that kept people from being able to get to the polls to vote. So significantly, citizens began to protest, they began to march. Some people even gave their lives just for the right to vote. Now, also in the 15th Amendment, there still hadn't been a right to vote for women. Women were not given the right to vote until, anybody know? 1920. Very good. You guys have been paying attention and doing your history. As you can see, whether you were a white male who didn't own property, a non-white male, or a woman who was at least 21 years old, the right to vote still wasn't freely or automatically granted to those who were citizens of the United States. So what does this mean? What does it mean? How does the right to vote affect you all sitting in here? We have everyone from middle school and high school, so about 11 years old to about 18 or 19. How many 18-year-olds do we have? Do you have any 18-year-olds? 17. Okay, we got a few 17-year-olds. So we're going to talk about a gentleman, or two people, a gentleman by the name of Mr. Concerned Citizen and Miss I Don't Care. Okay? So I want you to meet Mr. Concerned Citizen. Hello?
Hi, is this Miss Smith?
Yes, it is. How are you today?
Miss Smith, I haven't been having a good day, and I'm hoping that you can help make my day better.
Sure. What can I do for you? How can I improve your day?
You can improve my day by making a new law. I don't like all of this Instabook, Facegram, TikTok, Snap, or Tweet that's going on. I have a daughter, and she's only 13, and she is constantly on these social media apps.
Well, first and foremost, Mr. Concerned Citizen, do you vote?
Oh, listen, you better believe it. I voted in every single election since I registered when I was 18 years old.
Okay, well, we can work with that. There's something I can do to help you. So let me make a few calls, and I'll get back to you, okay?
Well, what I'm really looking for is to find out if there's a way that we can restrict social media so that kids can't use them until they turn about 22 years old.
I actually like that idea. And you know what? You have called at the right time, because I have gotten many calls from parents asking me about limiting the right to social media for our children. So yeah, I will be happy to work with you on that law, okay?
Thanks, I'll wait on your call.
Okay. Let me check. Let's see. Palm Beach County Supervisor of Election, Mr. Concerned Citizen. Yep, he has voted in every election in the last 5 years. Okay, let's see. Hi, Charlie. How are you? I would like to introduce a bill, and I've got a gentleman who's concerned about his daughter and all of her social media, and we want to restrict the age to 22. You think that's possible, that you could help me champion that bill? Wonderful. Well, let's get started then. Okay, because you know we have an election coming up in November, and we want to get it on the ballot by then, okay? Thank you. Okay, what do I got to do? I need to get my aide to champion this, to write the legislature, to do, get some things. Sadia, how are you?
I'm good. How are you?
I'm good. I haven't seen you in so long. What? Are you 18 yet?
I am, and I just got my driver's license, and I'm going to college.
Great. That's all wonderful, and that's good. But have you registered to vote?
Yeah, I mean, because, my parents told me I had to, so.
Okay, good. So you know some of the issues that are coming up in this election, right?
Not really, no.
Okay, have you done anything to educate yourself on what the initiatives on the ballot are?
No, I've just been, Ariana Grande, Cardi B. There's a lot going on in life. I'm too busy with that.
I understand that, but, the election is only 2 weeks away now.
2 weeks? That's not that far, but, I got a lot of time before 2 weeks, so.
Okay, but make sure that you vote, okay? You gonna get to it?
I don't know. Maybe.
Okay, but you understand that people gave their lives so that they could vote.
Yeah, but that was like 50 years ago.
And you don't think that has any impact on you?
No, not in 2019.
Okay. All right, Sadia, but you think about it, okay?
Okay, I'll think about it. All right.
Wonderful. So it's November the 6th. It's 5:55. That initiative is being considered, and right now it's ahead by 50,000 votes because none of the millennials knew that it was on the ballot. So it's 11 o'clock, and the election results are in. Guess what? You got to be 22 to use social media now. How does that affect you all? Excuse me? Excuse me? You can't go to school? Did somebody say you can't go to school because you can't use social media? How important is the right to vote? If you knew that there were going to be initiatives on that ballot that would affect you to that event, would that change whether or not you registered to vote and whether or not you went out and actually voted? It would, wouldn't it? So what relation do you have to one person, one vote, and what these beautiful judges talk to you about in our Constitution? How do those two go together? How does the right to vote in our Constitution, what relationship do they have? Nothing. Did somebody say nothing? Knowledge. Thank you. Knowledge. Knowledge is key. So if you don't know what's on the ballot, how can you have any input?
How can you have, like, if you don't know, then you probably, like, might not even participate in the election if you don't know.
That's correct. And that's what my friend did, correct?
Yeah.
She didn't bother to worry about voting, did she?
Yeah, but voting's actually really important because, like you said, people gave their life for it, and it could have impact on you.
Exactly. Who can tell me how old you have to be to register to vote? 18. But what can you do when you're, somebody over here got it?
17. You can
17. That's right. You can't actually, you can pre-register and get your voter registration card at 17. And last year we had our first district-wide voter project where we actually registered people at the schools. So when you have the opportunity to register to vote, make sure that you do exercise that right and participate in it, because it could impact you. Something as significant or as what may seem to be insignificant can be very significant to your rights and to things that you like to do. Thank you.
Thank you, Ms. Middleton, and to Mr. Chio Reed and the team from the F. Cunningham Bar Association. We will end with our judges and our final slides, and then we will very organized, in an organized way, allow you guys to leave to go to your buses so that you can get back to school on time. So, Judge Rowe?
Okay. Yes.
You blindsided me.
Sorry. Just about the registering to vote, I was just talking ironically to my mom earlier this week. I registered to vote on campus at 17. I distinctly remember that day. I remember who I was with and when I registered. And it's the most important right that I've exercised since that time. So I strongly encourage you to register to vote when the time comes for you to do so. Many of these slides were prepared by the National Association of Women Judges, of which I am proud to be a member. It was formed in 1979, and within that organization is what's called the Informed Voter Project. And through the Informed Voter Project, we go out into the community. This is one of the best things that I like about my job. We all three of us are so very blessed to be on the bench and then to be part of the process of educating and promoting civics education to the youth who Mr. Lurvy has correctly pointed out. You're the leaders. You're going to be taking over for us someday. So I want to just give a quick shout out to the National Association of Women Judges. They have produced a film in which Justice O'Connor, who's retired, is featured.
On behalf of ABOTA, I want to thank you all for being here. We did bring some mini constitutions. I ask that you take a look at those, go home, read them with your families. They're important. We're really proud of them, of the United States Constitution. We appreciate all your time and attention today. I think, or we want to see if there's a...
I want to just Judge Connor and Judge Fuhrer to say something if they want to. Go ahead, I'll go.
I very much appreciate all the work that ABOTA does to make sure that we do maintain an independent judiciary, we do maintain the right to jury trials, and just the Constitution as a whole. So, ABOTA, thank you very much for all the work that y'all do.
I want to thank all of you for your participation today. You all are insightful and smart, and you are our future. And this is one of the reasons why I enjoy coming and speaking to students like yourself who are engaged, who are, who know what's going on. You guys know the amendments better than some lawyers, perhaps. So I appreciate that. I want to thank ABOTA and the Palm Beach County School District for having us here. And it is truly a privilege for me to serve on your bench. And I hope you guys continue and come visit the courthouse. These are public courthouses. You can come see trials. You can come see judges in action all the time. Taxpayers pay for our courthouses. So come see, observe, and learn. Go to law school and be engaged in your community for sure.
And thanks again for inviting us all. I am also a very proud member to be on ABOTA. I am one of the judicial members on ABOTA. They swore me in last year. It was another proud moment for me. And we'll end. And thank you all for inviting us. We are truly blessed and honored to be here among you. Can we play the video? I don't know.
Can you press play?
Our Constitution is celebrated as the backbone of our democracy, but our Constitution cannot survive without fair and free courts.
Americans look to their courts for fairness, free from the influence of politics and partisanship.
Learn how you can help keep our courts fair and free at the Informed Voters Fair Judges website, or join the conversation on our Facebook page.
Our courts are what they must always be, fair and free.
Thank you all so much for coming, and I'm going to have the chaperones, if you guys want to stand by your students. We do have the judges that are here. If you want to take a second to maybe come up and shake a hand or take a photo, you can do that. But we ask that you get back to your buses as quickly as you possibly can so that you can have an on-time departure. Thank you guys so much, and we look forward to seeing you again next year.